Ready? My name is Richard Stockford. I'm the owner of Drain Waste Ventilation Stockford Contaminant Pipeline Shell. My business number is 779156538. It is a real business. I'm an innovator and inventor for Davison Inventions. This is a company that's an innovator company that's going to create my design, test, modify, put on the market. And we are having conflict of interest act with a lawyer. And this is recent news. We're trying to link this court case with my court doc number, which is, just one second, my court doc number against Enbridge Inc. is WC-34-23. I'm the plaintiff, Richard Stockford, and I'm up against Enbridge Inc. Incorporated. Have them up for $40 million for using my intellectual property, and I own this on LinkedIn. And here's the recent news. Undo Line 5 shutdown order. Federal government's filing urges U.S. appeal courts. Headlines. I think they should be shutting down because they're not using the safety protocols and procedures that they were offered, and they're holding it up until 2030 so they don't have to put the money into it. And when a pipeline leaks, they don't actually pay for the pipeline spill. Insurance companies do. Take a look, bud. Right there. It will give harm to shut down, but when you shut down and do these modifications and open back up, you'll have a safety program. And here they are right here spending $14 billion on utilities after I filed this in the courts. It went from $78 billion from $14 billion. How much more are they going to spend when I have them up for 51% assets? Okay. This is the statement of claim. This is in the Court of King's Bench of New Brunswick. I've been recently kicked out of the courthouse and exited out of the courthouse because I have to speak to a judge, and I guess it's against my rights to speak to a judge, and I'm pretty sure that's against the law, not giving the person the proper help to a proceeding that he needs assistance with, but not containing to the case. He's allowed to ask questions and other related information that could be arising with this type of court case, because I have Mr. Peter Crocco out of New Brunswick, Woodstock. That was my lawyer at first that I hired, and had verbal confidentiality agreement over the phone, visits to his office, giving him a USB chip with all my presentations in early 2018. April 2018. And what I'm up against is Line 5 tunnel projects and the whole Line 5 process. So the statement of defense of Enbridge, I'm going to read it to them, then I'm going to read my statement of claim and show the evidence behind everything, because I have the research evidence. I'm not lying about anything. I have no reason to lie. I've been trying to move my business forward, and they're simply just ruining my career, which is not fair. So the defendant, Enbridge Inc., denies each and every allegation contained in the statement of claim, except where specifically omitted herein of further puts the plaintiff, Richard Stockford, the plaintiff, to strict proof of. Okay, we're going to show the proof. I'm pretty upset about this. This is not fair. Enbridge has no knowledge and facts alleged in the plaintiff's statement of claim. Without limiting the generality of the foregoing, Enbridge specifically denies that it has any knowledge of the plaintiff. Enbridge specifically denies that the plaintiff is the owner of any technology, classifications, infrastructure, real estate projects, inventions, patents, design plans, or pipeline self-cleaning systems or associated pipeline protocols, procedures, and techniques that is alleged technology referenced by the plaintiff. In the statement of claim, Enbridge further denies that the plaintiff has any recognizable legal, equitable benefit, interest in the alleged technology. But here they are building it. Enbridge denies that it has any knowledge of the alleged technology whatsoever. But I have 3,500 followers on LinkedIn profile, and I've been commenting on their stuff. So on Enbridge's profile, and they say they don't recognize me when I'm the master engineer behind this technology, and it is my creation. So they are not authorized personnel to be building such a transportation system, secondary contaminant pipeline shell for reduce, reuse, recycle, and recover of any lost product within a pipeline system. This pressure relief equipment is very important for today's age. I'm going to continue on with the statement of claim. Further, or the alternative, in the plaintiff is the owner of any alleged technology. Enbridge specifically denies that it has used or adopted any manner the alleged technology. Further, specifically denies any infringe intellectual property. I'm going to show you this page for evidence. Rights to any or other rights, priority otherwise the plaintiff in the alleged technology. Enbridge specifically denies that it owns or has ever owned any money or other obligations to the plaintiff. But I have legal rights to this work, and they're skipping out on paperwork through the government because the Liberal Party actually works for Enbridge and accepts pipelines. So this makes them makes this a complete conflict of interest act. Also, with Mr. Peter Crocco involved, he was involved with a recent claim of mine when I injured my back in an accident where I fell through a set of stairs, and they tried to only give me $10,000 for being out of work for nearly 2 years. So that's a conflict of interest act, and my contract should be set aside for that because I was in hard financial needs. So I had to accept that money, and they only gave me $30,000, which I took the second option, what they have offered, because they know they don't want to see me have any money or be successful at anything. So I believe I should have rights to that whole complete $91,000 because this lawyer lied to me when I gave him my information about 3 weeks ago in his court office, and he said he couldn't help me because there's conflict of interest act with my back injury claim, but they simply are using that against me, but they did not specify that they were protecting Enbridge at that law office, which makes them criminals, and they are criminally active at the moment, and they're wonder how many more people lives they're ruining and careers they're ruining. I'll continue on. I'm really upset about this. I'm also doing this live. I support Red Bull, Gatorade. Just love that stuff. I'm gonna have a drink before I continue on. It's pretty good stuff. Keeps me awake, motivated. Alrighty then. Enbridge specifically denies that it owns or has ever owned any money or obligations to the plaintiff. Enbridge specifically denies that it has conveyed any energy policy and safety. Enbridge specifically denies that it has conveyed any of all statutes mentioned in the statement of claim, including but not limited to the Transportation Act and the Pipeline Safety Act. But they're not testing and modifying this equipment before they put it in commission, which is against energy policy and safety, and also the Pipeline Transportation Act to test and modify equipment before you put it into commission. And this full, complete carbon capture project is connected to vessel stabilizers via pipes, and they're combined as one unit to pipeline securement system, making this for environmentally sensitive areas for operations for bleed-off points and full control operations, man-powered pipelines. We need to be putting in the commission and installing these and testing and modifying the equipment properly, and that all comes underneath my contract. and they have also opened up a stock market for $1.1 trillion within the government at $1.1 trillion. That's a lot of money before they even put out the work. It's like they're gambling with my innovation before they even install it. Enbridge specifically denies that it has conveyed any energy policy. Enbridge specifically denies it has conveyed any of all statutes mentioned in the statement of claim, including but not limited to the Transportation Act and Pipeline Safety Act. The plaintiff's statement of claim lacks and does not provide the specific particulars of the alleged contained therein, because they don't understand the technology and what they're building, but they're holding up my innovation on their private network, where if they post anything about that specific project on LinkedIn or Facebook or even on TikTok, they would be they could get sued for copyright infringement because they're using my work. That's my data information. That's my bank. That is my bank that they're corrupting at the moment. The plaintiff's statement of claim fails to disclose any reasonable cause of action. The plaintiff's statement of claim fails to deny plaintiff's specific, legal, equitable, beneficial, or other interest in the alleged technology itself, and the part of alleged technology of any other technology whatsoever. That's a big word, isn't it? The alleged has infringed upon. The infringement which is expressly denied. It's always denied, denied, denied. They're not backing up their information. You just wait. The plaintiff's statement of claim further fails to identify the plaintiff's specific form from making up the alleged technology, saying I made this up. I did make it up. I created it. I'm the creator of this. They're not certified people to be running these operations, and neither is the lawyer. So he has no right to say anything behind this technology. We need certified people, and they're not certified, so they're lying. This gives me obligations to take over 51% of their company, and they should not be spending any more money in cash, in debit. It should be limited until this court case is settled, and we end up linking this actual court case to the Line 5 projects and putting this into the courthouse properly. And the courthouse is holding everything up, saying this could take over a year to get done. But they say the plaintiff of any technology whatsoever, again, Enbridge has alleged infringed upon, the infringement expressly is denied. Enbridge requests claim against it to be dismissed with cost. Well, how about my cost and all the time I put into this innovation? My literature is correct. You're improperly identifying safety equipment. Enbridge intends to proceed in the English language, so I'm proceeding of saying withdrawing from representation. While the client can terminate the lawyer at any time, lawyers do not have the same freedom to withdraw from the client, because he dropped me like a dead fish in the water, Mr. Peter Crocco in Woodstock, New Brunswick, and in general can only withdraw services for a good reason. He did not have a good reason. He said he was too busy at the time, but he jumped ship, went to my competitor, called them up, and probably gave him all my information, and he's not going to keep confidential information while he's making money against my competitor when he was obligated to me at first, and he's got to have good reasons and significant notice, and he didn't give me that. Now, I explained myself many times on LinkedIn, YouTube, have presentations. I'm just going to let you take a snapshot of this and show you my, that's my cover letter I have. I have wrote that. Sincerely, Richard Stockford. Okay. This is going to be my amendment. I'm making this live. I'm not going to edit anything. I'm just going to put it online, show that everything is being corrupt at the moment, and this is real information. This is researched. We have proof and evidence, and the judge shouldn't be taking this should be taking us into consideration that we are in fact the developers behind this innovation.